to address some of John Phillips on behalf of Stephen Kyle Underwood, to address some of the questions pending as trial counsel, and I've had bits and pieces of this case since its initiation. It started off with a partner in my firm when I was a fairly young, much younger associate. It's been around that long, 2006, and he pled battery because we had a client come to us that said, I was assaulted in Panama Hatties. Well, the next question was, do you recall it? No, he had complete amnesia, and that was Stephen Underwood, Kyle Underwood. So the complaint was drafted by Mr. Lanier to that effect. There was a key day of depositions on February 23rd, 2009, and then March 25, 2009 that I attended, and we literally deposed every bartender, every barback, everybody involved with Panama Hatties, and every single one of them that could recall described that restroom as slick, slippery, nasty. When it's busy on a busy night, college night, it's a hazard. That's the way they described it.
Was that testimony before the trial judge?
Yes, Your Honor, quite a bit of it. We either read it in by deposition or had it presented to the trial judge by live witnesses. So that's when the evolution of the complaint happened. I actually amended it. The first count goes to the negligent kinetics, kind of like the analogy if you three walk back and bump into each other and somebody slips and falls, that's negligent kinetics. The judge even asked, I believe on the record towards the end, what is covered by this policy in a bar and nightclub situation, and we feel it was overbroad and vague with some of the issues that have been pointed out. But that wasn't necessarily what happened, because I have a client that didn't know what happened. I have a bouncer that says, I didn't intend to cause any contact. I just had a guy coming at me. And so we also alleged the myriad, I think 11 different defects with this restroom. And what's extremely important to note, and the judge toured the scene. The judge went to the restroom for an in-camera inspection, which you three are not allowed, which was pretty funny to have the four suited gentlemen.
I assume that was before hours or after hours.
It was actually during hours.
Not as a customer, right?
No, sir. And we all viewed it, and it's a very just simply built wooden box where there's one stall and a big heavy wooden door that swings out, and that door literally closes off the rest of the restroom, but for about 8 inches. And there's evidence, and again, the judge viewed that. And so what we're dealing with is something that happened literally 10 minutes before last call in a bar. Very quickly, the bar, the evidence before the trial court was the lights were cutting on and off. This young man, my client, wanted to go in, get his business done, and hit the road. And bouncers, if you've been in, it's probably been a while, ladies and gentlemen, but if you've been in a nightclub situation where it's closing, the bouncers are yelling at you saying, get out, go home. And so that was going on, and one of their employees stuck around and was in there. And Kyle was, as he does, kind of goofing around, saying, hey, get out, man, get out, I got to go. And what happened next, there's the difference in perception and reality. And what Essex is holding on to is the perception that even the person that drafted the complaint had, was that this was a bar fight in a bathroom. But the reality from all the competent evidence, and there's none contrasting, was that the reality was this was one guy rushing in and one guy rushing out, where neither one had an intent to harm.
Thank you, Counsel.
Thank you.
Minute and 12 seconds.
Thank you, Your Honor. The hole in the donut here is the fact that there is simply, it is devoid of any evidence that two parties came close and that Mr. Underwood slipped without them ever coming into contact. And I noticed no record citation afforded to the court to that effect either. It is undisputed that Mr. Underwood fell after being in contact with Mr. McDonald.
Well, this is a
And-
case where the trial judge even went and viewed the premises and
Right.
saw everything, and you heard all the evidence and testimony, and
And
how are we supposed to say that he was wrong based on what we see in this record and what was presented? I mean, it makes it difficult, doesn't it?
it does, but he had no evidence that Mr. Underwood slipped first. None. Zilch. Absolutely none, Your Honor, taking all of the testimony. There may
The
have been
trial
a
judge went and he viewed the premises, he looked at everything, he heard everybody's testimony, he said, this is a negligence case and a premises liability case, period, and you got coverage.
But based, yeah, but
that's
based, I beg, sorry,
And that's it.
yeah, based on what evidence that Mr. Underwood slipped, there was none. There was none. There was no evidence that he slipped. Nobody saw him slip before he went airborne after being contacted by Mr. McDonald. The reason that you're bumping into each other going through the door is not battery is because that's not an intentional touching. This court in Paul versus Holbrook said quite clearly, no evidence of an intention to cause harm is necessary, but there has to be an evidence to cause contact, and that contact, if it's harmful, constitutes a battery under the law, and that's what happened in this
Okay,
case.
you've gone over your time.
Thank you, Judge.
Okay, thank you both very much. Well argued on both sides.